in this topic as soon as I saw the rule change, because I know that a lot of folks were curious, and I've seen some of my mental health colleagues on social media threads and conversation groups asking the question, what are the implications of this for me and my practice if I'm a group practice owner? So I thought, for me, I didn't want to sit around and wring my hands and worry. I'd rather get some expertise and find out directly what the implications are for me as a group practice owner and for everybody else. So Sparrow Search Services is the specialty recruiting firm that I run in partnership with Erica Love and Chelsea Knackers, who are my team members, and we help practices recruit mental health clinicians because we speak mental health clinician. All of us are practicing mental health professionals, and we bring that expertise to organizations who are looking for help adding clinicians to their ranks. So it's been a really challenging market, I know, over the last couple of years since the pandemic put even more pressure on our very pressured mental health system. And the story is there's a shortage of clinicians everywhere. So we've been able to kind of engage with clinicians who might be looking for a new opportunity, might be looking for something new, or if they had their druthers that just have a couple more things that would be different or be better for them. And we do that work for organizations, group practices, hospitals, nonprofits, and really enjoy partnering and meeting with new people. So that's a little bit of our commercial and the sponsorship this morning, afternoon, whatever time zone you're tuning in from. But without further ado, I want to introduce our speaker today, friend, colleague, David DJ Holt, who is a healthcare and business attorney and been practicing law for over a decade, focusing on working with businesses in healthcare. He's advised hundreds of healthcare businesses on transactional matters, specifically labor law, distinctions between employees and independent contractors. We've got the guy, we've got the expert. And one of the things I appreciate about David is how direct and forward he is in a very kind, not aggressive way, but assertive way. And he's always been helpful for me when I've had legal questions about practice and business. So David, I will make you the host here and you can take it away. A couple of ground rules. If you have questions, please put them in the chat. We'll be monitoring the chat the whole time and adding your questions to David's plate. We'll try and be thematic in that if the same question comes up again and again and again, we'll see what rises to the top, if you will, and we'll ask those at the end. I know David has some great information during his presentation, and so some of your questions he may answer without you having to ask, but we'll definitely have time at the end for Q&A. And then this is being recorded. If you would like the recording, please contact me after the webinar is over, Andy@sparrowsearchservices.com, and we'll put our emails in the chat as well. So David, you have the power. You have become the host. Take it away.
All right, cool. Thanks, Andrew. Love the introduction. I should really hire you as my hype guy or my marketer. So really appreciate it. And thanks for hosting this. We're going to chat about the U.S. Department of Labor rule that came down and I think caught a lot of people by surprise. And what I'm going to do is really try and focus on the top legal responses that I'm giving to clients that I think would be broadly applicable to a lot of you. Just off the bat, I wouldn't be an attorney if I didn't give a disclaimer, so I'm just going to read it out since this is being recorded, which is that this presentation is educational in nature. It's not a substitute for legal advice to analyze your particular situation, and we're not liable for any of your reliance on this information or its accuracy or applicability to you. Hire competent professionals or assume the risk in not doing so. All right, without further ado, let's get into it. And actually, just to make sure that the chat's working, why don't, while I'm going through here, why don't you just throw in the chat quickly where you're from and maybe how many workers you have, whether, contractors or employees, doesn't matter. Throw that into the chat just so we can make sure that it's working. But I'm going to jump right into it. So what's going on? So in effect, the Biden-Harris administration passed through the U.S. Department of Labor a rule that is going to go into effect on March 11th, 2024. This is making the previous rules for how we differentiate between an independent contractor and employee a little bit strict, as in favoring more of an employee status. as well as also giving the government, specifically the US Department of Labor, more power to overrule a private decision. So what's coming down is what's called the six-factor test and the economic dependence test. It's called a few different things. You'll hear totality of the circumstances and economic reality, and I'll explain what that is. But bottom line is this is the strictest uh, ruling that we've had yet. I won't go into the history of kind of what's happened over the last few administrations, but this has been in the works, and it is currently coming on March 11th, pending legal challenges. There are quite a few legal challenges in the works right now, so more on that kind of at the end of the presentation. But who needs to comply? So is this applicable to you? This is a federal rule, so we're dealing with federal law. I'm based in Minnesota as an attorney, but all attorneys are presumed competent to comment on federal law, although what's complicated is that state law may also apply. But in general, if you have annual gross revenue over 500,000, this will apply if you're doing any interstate commerce, so any multi-state practices, this would generally apply to you as well. I'll put an asterisk on that one, but safe assumption would be that it applies. If you accept any public funding, so Medicaid, Medicare, TRICARE would apply, and then there's other limited situations that I'm just assuming that the audience here is mainly healthcare businesses, so I won't go into those. Oops, guess I gotta click up here. So what are the six factors? Some of these may sound familiar to you based on what you may have already been doing with your independent contractors or maybe other advice that you've been given. Largely what's happened is previous factors have been expanded upon, and then there's kind of been some sub factors as well as some trump factors that I'll go over. So let's just go over each one. I'm not going to go into the sub factors of each one. I'm really going to get to kind of the meat and potatoes of the presentation, and rather than kind of dissect all the factors. But number one is the opportunity for profit or loss depending on managerial skill. The depending on managerial skill kind of always throws people off. I'll kind of talk a little bit about that later. Second is nature and degree of control. Pretty traditional factor, pretty common sense. Third is going to be investments by the worker and the potential employer. Four is going to be the degree of permanence of the work relationship. So how long it is, right? Is it indefinite? Is it 30 days? Is it a year? Something else? Five is going to be the extent to which the work performed is an integral part of the potential employer's business. I don't really like this factor because I think by default for most healthcare businesses or mental health clinics operating with a lot of independent contractors, five is a pretty difficult factor to pass. And then six is also skill and initiative. What's frustrating is over here on the right is that the US Department of Labor is allowed to look at the totality of the circumstances. And so no one factor or even group of factors will be determinative or given more weight than the others. Rather, the government's allowed to go in and look at everything that's going on. And more importantly, whereas we would traditionally look a lot through the actual written contract, now the US Department of Labor is given a lot more power to look behind the scenes in your actual behavioral control. And one of those, kind of that goes hand in hand with that analysis, is what's called economic dependence. And so economic dependence, as the name would suggest, would be an individual that's economically dependent on this job or this independent contractor relationship, so much so that without that dependence, there might not be anything else there. That would suggest an employment relationship. Oops, is the PowerPoint not up? Oh my gosh. Let's see. Hey, Andrew, do you want to help me here? I guess I may have had a false start on the screen share.
No problem. Yeah, I was noticing that. I remember how cool your PowerPoint was, and I know we wanted to see it. Let's try this again and make you the host here, and then see if we can see your PowerPoint.
Thanks for those in the chat. I just got so excited that I ran off with information. I built this beautiful PowerPoint. So let's see. There we go. Whew. All right, how's that? Give me a Give me a yay or nay in the chat here. And can y'all see that? Anybody see that? Okay. Cool. I'll show you what you miss. It's a scary picture of me reading the disclaimer, and then effectively what I was reading before and who needs to comply. The beauty is that we'll have Andrew shoot this out to everybody afterwards, so you all get a copy of this as well. I was on this slide, get you caught up here. We were just going over the 6 factors, and I was moving on to the next slide. Okay. I just want to jump right into the top tips since we're kind of limited on time, and I do want to leave some time at the end to really dig a little bit more into some of your questions. And so I'm going to go right into what I would recommend in terms of immediate actions to take. Again, based on your circumstances, some of these are going to be different. The frustrating thing about this rule is it's a multi-factor test, right? And so the name of the game is to try and win on as many factors as possible so we have a nice legally defensible position if we were in an audit. So, you know, in a perfect world, yes, you do everything, every tip that I tell you, but I just don't think that's realistic. Just to make this a little interactive, why don't you all put just type kind of any emotions that you're feeling into the chats, and I'll kind of monitor those as well. I'm just kind of curious as to, what this rule coming down might mean for you. I mean, I know personally, as an attorney, you would think a rule like this is, oh, great, a bunch of new business. It's actually, we do not feel that way because for attorneys, it's actually very difficult to advise on rules like these that are rather ambiguous, right? It's not fun. It creates a lot of exposure for us to advise on it, right? And so, to be perfectly honest, I'm not very thrilled with the rule. And also as a business owner myself, I don't really enjoy seeing rules change between each, different president or different reign. I'd like to have more consistency. Anxiety and worry. I'm seeing a lot of anxiety, confusion, and a bit frustrated. Yeah, I mean, I think all of my clients have shared the exact same emotions. And again, I'm not particularly thrilled with how quickly this rule came down. Uh, there was a pretty aggressive commenting period, but for a small business owner trying to put something up in 2 months is very difficult to do, right? We got a business to run, we got lives that are going on. So I share your emotions there. Let's jump into the tips. So first off, right off the bat, your independent contractor should file a legal entity. And then I say, and actually utilize the legal entity as a business, right? So, yes, filing a business and turning this into a B2B or business to business relationship, that's great. That should be a really good defense. But under the totality of the circumstances test, it would be suggested that the government can, go beyond that and look at it as, just a superficial filing. So we want to do a little bit more than just the filing, which is actually scary to think about, right? In the legal world, we call that piercing the corporate veil, which is usually a very high standard. You're usually given the benefits of filing an entity without really, as long as you operate like a business, you should get all the benefits. Just the degree of the strength of the government's reach here, in my mind, is just a little bit concerning. The second one is we want to allow your workers, and by workers I mean independent contractors, to negotiate their rates of pay for work provided. This suggests more of a business to business dealing as opposed to, hey, take it or leave it. We have all of the power over the relationship. So being able to document something like that's going to be very helpful. Also, I would hope a lot of you are already doing this, but allowing your independent contractors to reject work and choose their own schedule and also document as such. Next step would be to confirm for some of you that are doing renter rooms or kind of the rental model. You might call it a facility fee, an administrative fee, a rental fee. We just want to make that optional for contractors, or at least have language that would suggest it's optional, or only as a formality to enable billing. And Already seen, looks like some questions that I'll probably circle back to at the end about, I'm well aware of the billing arrangements when we are working with payers and how we need to, list those, um, and how that would go through the system. And so, um, right, we want to have language that would both comply with the US Department of Labor rule, but also not screw up all of our billing, right? Um, Another tip here, contractors pay for and do their own training. So for example, HIPAA, any CLEs, any specialized trainings, really to advance their own careers without guidance from you, the company. Let's see if I can grab some of the questions while I'm coming to the next slide here. So just gonna scroll up. Okay, with insurance dictating reimbursement, how can we negotiate rates? Yeah, so I mean, I would expect that. So it actually brings up a whole different, I could do a whole another presentation on this, but um there's what I would call your retail rates, like your off the shelf rates, and then there's what insurance reimburses you, right? So assume that I'm an affluent patient that comes through the door. I have unlimited money, right? What would you charge me as my rate? Now, in a perfect world, that rate would be your retail rate. You might send that out to UCare, Medica, whatever, and of course they're going to pay you, 30 cents on the dollar. But having a contractor able to negotiate their retail rates would be how you negotiate the rates with a contractor there. Great question. Since insurance dictates reimbursement are then yeah, they'd be negotiating if you're doing it sounds like you're doing a percentage fee split. That would be one way where they would be able to negotiate. Yes, that's a good one good way to do it. Blah, 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 blah. Under the previous rules, the DOL specifically said that they didn't consider the existence of an LLC when determining if someone is an employee. Has that changed under the new rules? Largely no, but it puts you a little bit higher than an individual who is company to individual, right? So it's not a trump card. Otherwise, I just have one slide in this presentation and I'd be done. I just, head out for my Friday. It's going to be a multi-factor test, but having the entity is going to be one of the best defenses. CLE is the same as CEUs. Yes, sorry. Attorneys, we call them CLEs, CEUs for you. So we're speaking the same language. I'll let Andrew kind of accumulate some of the other ones there towards the end, and I'll keep moving here. Similar to the previous slide, I want companies to really stop training their independent contractors or do the absolute bare minimum. So don't provide HIPAA training. A true independent contractor should be in charge of their own HIPAA training. They should understand what HIPAA is. They should have their own internal policies and procedures manual, probably a long, boring 90-page, internal written document that says what HIPAA is, what's a breach, sample notification letters, their little sample log if they ever did have a breach, and what to do. They should really be in charge of their own compliance there. You shouldn't be spoon feeding them that or providing your own training because that looks and feels like an employee. Next tip here is we want to make sure that all independent contractors are providing marketing, advertising, or other efforts to expand their business. And in a perfect world, they provide you with documentation. Now, this might feel like an employer thing to do, getting documentation. When I say provide you with documentation, I think it would be we could confirm if we were under audit that they actually did these things. We're not, actually asking them to send us one of their, sweatshirts of business apparel, but we want to have, I'm just saying 5 clear examples of these nice independent things that they are doing that looks and feels like a business. Here's some examples. They had their own website. That would look great. Business cards, paid promotions, booths at conferences, business apparel, business branded materials. Here's a good one, updating their LinkedIn and other social media to reflect their business name, not yours, right? Kind of a little mini distinction, but if I'm an auditor and I'm just jumping onto the internet, which is really just a big electronic billboard for advertising, am I going to see everything associated with your company or do I see some sort of independent business? Hand in hand with that, I would love to see removal of contractors from company websites or extremely clear disclaimer of the relationship. Um, I know, a lot of my clients aren't very thrilled about that one. I say, if you're going to keep them on the website, at least please make it extremely clear and just put, the independent contractor or not an employee, right? Like nice keyed up language for if an auditor actually landed on the website and then said, hey, well, I can't tell the difference here. This looks like they're associated with you. And it would for the average consumer. Business bank account and payments to an entity, not an individual. I mean, again, if they're filing an entity, like I said before, the payments or the contract should be a B2B, business to business contract, and therefore you'd be paying from your business to their business. I see your questions, I acknowledge them, and I'm super excited to answer them a little bit later. Let me just get through some more of these tips. This is kind of a repeat, but document the occasional instance of advertising or marketing efforts of the contractor actually resulting in them bringing customers to their business, which they're probably just filtering over to your, billing slash, the major entity. And also consider compensating the contractor more for this. So if I'm a truly independent contractor, I'm doing my own marketing, I'm paying for my own business cards, I go to the mental health networking booth, and I bring in some new patients, they've effectively done the marketing, right, to acquire the new patient. Consider paying them more for that because that suggests some sort of independent business relationship, that they're doing something that's entrepreneurial and they're taking that extra step. That's a pretty advanced win in terms of the factors, but something to consider. Switch your independent contractor agreements to a fixed 1 year term maximum, okay? With a negotiation window where we actually engage in meaningful negotiations before the end. Now, as an attorney drafting an agreement, we don't like when there's an automatic end date because most people forget about it and blow past it, and then we're in this crazy gray area of law. But for purposes of winning in one of these factors, what I would love to see is that there's a fixed term, 90 days, 60 days before the end of that, we're engaging in meaningful negotiations, and we're actually showing and demonstrating that they have some sort of power in a business to business relationship. Okay. Don't restrict their work. So no non-competes anymore, okay? An independent contractor, arguably, were difficult to enforce anyway in previous independent contractor agreements, but definitely under the U.S. Department of Labor rule, no non-competes. It's specifically outlined as a sub rule. Next one's a little bit trickier, not to be confused with a non-compete, but a non-solicitation is where we're telling the worker, the independent contractor, that they can't actively solicit patients or clients. I would say we either remove that provision or we really clean it up in the fact that if they independently brought in their own patients, they should be able to bring those with them. I won't go into all the defenses and arguments about what is solicitation, what is not, and a patient's ability to follow their practitioner and what can and can't be restricted. But definitely for individuals, patients that come in through their independent marketing efforts and then become part of the larger company billing, upon exit, allow them to alert those individuals that they are leaving. And this is just like smart legal, something that you should probably be doing anyway, is how are we going to address a breakup, right? One great example is I'll actually draft in a contract sometimes exactly what we do in a patient notification letter that we've almost already pre-agreed on the template to go out in the event of any termination. So we're just kind of getting ahead of the potential breakup. Last one here. Force contractors to seek additional work elsewhere and consider limiting the contractor work to a maximum of 20 hours a week in order to prevent the economic reality reliance. So I'm going to unpack that one a little bit because this one usually frustrates my clients the most. So um, the economic reality, or sorry, economic dependence. Effectively, what we're saying is that if somebody works only for your company and they work for their 40 hours a week and they've been doing it for the last 3 years, this is the exact type of worker that I would challenge a client to consider switching over to an employee, right? All the factors and all the things that I do in the world are not going to remove the simple fact that that individual is economically dependent on this income, unless there's some, magical 80-hour a week worker and they're moonlighting like mad and this is just half of their working hours, then maybe, but I suspect that most individuals are in the exact same situation where they're just working at the same place. So it's kind of this like really tough dance, right? We don't want to like tell these independent contractors what to do, but also in order to save our butts and actually keep them classified as independent contractors, I think our interests are aligned, right? The company wants them to stay as independent contractors. I think most independent contractors prefer to actually be contractors, but blame the attorney, blame the government, whatever you want to do. I think we're at a point where some of those people are going to peel off into employees, and the rest, if we're doing it right and we really want to have a slam dunk under an audit, I would love to see them working elsewhere. And so I've actually had some of my clients who are similarly situated. They're actually cross pollinating, I call it. So they're cross pollinating their contractors where they basically have, we'll just say, 4 full-time contractors over here, full-time, and 4 full-time contractors over here. They're strategically switching them down to about half their workload, and then they're working at 2 different places. And then, of course, the actual business owners, not in writing, but have, a general agreement. We all know what's going on. Here's some workers that are likely to be employees. So I take a conservative approach to my legal practice. I'm sure that you could find some other attorneys that would advise differently here. But interns, clinical trainees, and other workers that require supervision in order to work, I'm not confident that under this rule that those individuals could survive as contractors anymore. Or you're taking a big assumption of risk if you are going to move forward with those. These are individuals where, due to the fact that they require supervision, the guidance made it very clear that that is it's a pretty strong factor, and it would be tough to go against the assumption that that individual is an employee. I won't go into some creative ways to try and get around that here, but you could consider staffing individuals in a way where they come as a package deal where the supervisor and supervisee, who are employees of some other company, kind of contract with you together. So the employment consideration becomes their issue and not yours. I kind of hinted at this before, but if you have workers that have only worked for your business for a year or more straight, they're working 30 plus hours, 40, whatever. They're only working with your company and they really have no desire to do everything that I've mentioned here and to work elsewhere. That's likely an employee, right? We can get you the best drafted written agreement. We can fight as many factors as we can, but we're not going to get over the economic dependence assumption right here. Okay. Higher level, I see a lot of questions coming through, which is great. I will circle back to those. I'm moving at a nice clip here so that I'm going to be able to really tackle a lot of those questions. Just general, one of the things that I see my clients talk about is they think employment law is this big, expensive and extremely difficult thing to do. I would submit that it's not. I mean, it's a learning hump, but or learning curve, whatever, but it's not that bad, right? Yes, it can be a little bit more expensive. I actually break down the costs on this slide, but you know, let's just kind of like work through our analysis if we were considering switching over some people to employees. So this may seem common sense, but like what are the pros of an independent contractors? Okay, we can add them and get rid of them really quick, right? They can just sign this one little contract, maybe yes, a W-9, and then poof, we're off to the races. Maybe if you're really thinking ahead, you're making them get their own professional liability insurance and list you as an additional insured. I think it's really easy to scale, right? Because you can add people real quickly. These individuals have no employment law protections or benefits, so you don't care about PTO, you don't care about breaks, you really don't care about things like harassment or quasi harassment or overtime. It just doesn't exist. It's kind of a low risk engagement for the company, and taxes are much easier, right? You pay them a big wage, they're in charge of their own taxes. They usually learn that by surprise when they have a big tax burden at the end of the year and they realize they're not actually getting the full amount. And then you just hit them with the 1099, right? Easy peasy. Cons, right? The biggest con right now, especially in light of this rule, is that it's much harder to classify correctly. And also, if you're doing things right, there's a lack of true control. So, you know, two cons. Employees, a little bit bigger um, analysis here. So, pros, okay, we can finally control and supervise them. We can have a more cohesive team. We're not living in this constant fear of misclassification and, frustration that the current administration changed the rules again. They're just employees, right? There could be some tax write-off benefits, both for you as kind of a owner employee as well as the rest of the employees. Cons, all right? There's plenty of cons, and these are also cons over here on the far right, but workers' comp requirements, you're required to get workers' comp insurance. Unemployment compensation differs by state as to how that actually plays out, and how, if it's a pooled system and how you pay for it either directly or indirectly. Paying for, benefit eligibility, if you're offering benefits under the payroll, you're paying more in the federal taxes. And then there's all of these protections over on the far right. We can't discriminate or harass. I mean, I doubt you're doing that to your contractors. I hope you're not, but there's certainly more protections as an employee. We need to actually consider minimum wage and overtime pay. So one of the biggest complaints I get from clients is that they're using legal fee split arrangements, and they don't know how to calculate what like a paid day off would be, right? It's like this crazy average, and you got to go, hire a math professor to figure out, how much would I pay a person if I actually gave them a paid time off in terms of like a fee split. So they're just getting a percentage of revenue that they generate. Same with overtime pay, right? For overtime, we are really not worried about that in independent contractor relationship. We don't care how much they work. There's the opportunity for profit or loss. With an employee, we are considering that. And, in Minnesota, we have it at 48, but under the assumption that federal law applied, you'd be at the 40 amount, 40 hours a week. Health insurance, FMLA, RISA, COBRA, OSHA, all these fancy acronyms for benefits and protections that are available for employees, some of which don't kick in until you have a certain amount of employees, like 50 full-time equivalent, but some of you might be there if you had to switch over your full workforce. I think this will be more useful to you all when we actually send out the presentation. What I try to do for one of my clients is, she said, what is it? If I have $100,000 and I'm paying that out to a worker, that's a contractor versus an employee, what is the worker going to get at the end of the day after taxes? Because I need to go and like pitch this to them. You're telling me I got to change all this stuff. Okay, that's fine. But now I need to tell these independent contractors that it might be a good deal for them, right? And to actually get them on board. So I tried to really break this down. This is, of course, based on Minnesota rules in terms of the paid time off. Whether or not you have that in your state's going to differ by state. But I tried to break down if I just grabbed $100,000 and threw it at an employee versus a contractor, where that would go. And you can kind of see some of the differences. You know, contractors pay a little bit more out of their initial payments and taxes, but then if you kind of get to the bottom, you kind of break down, okay, well, yeah, they pay that, but then also they pay a little bit over here. You know, it's almost the same, but the issue becomes all of these extra expenses that the employer is eating in terms of, you know, maintaining the system. And also, you know, paid time off and other benefit administration can get extremely expensive. It's also unpredictable for your workforce and can create other issues. CPAs, of course, or accountants love, you know, the switch over to um, employees because they have to file more taxes. They have to administer your payroll, which then results in increased fees on their end. Um, that one will make a little bit more sense when we send out the presentation. I actually want to note one thing. Um, what's really frustrating, but also interesting, I suppose, in a weird way, is that you've probably gotten different advice from your accountant or CPA as to, you know, how this rule applies. What is interesting is that the US Department of Labor actually has a different set of rules as of today than the IRS. So what that means is, from an IRS perspective, from a tax perspective at the federal level, you could have a legitimate independent contractor. But if we were under audit and under a misclassification under the US Department of Labor, they would have a different standard. What's also frustrating is that state law might apply if it's more strict, although I doubt you'll find more strict rules than this one. And then what's also extra frustrating is that other government branches may have a different standard depending on who's actually in charge of the audit. So didn't want to open that can of worms at the very end, but largely just to explain why you might be hearing different answers from your CPA or accountant than your lawyer or, you know, whoever else you might be working at with the federal level. I do have some resources here if you wanted to go and poke around at some of the FAQs and really dig deeply into the rule if you're going to kind of do a DIY approach. I also wanted to just add a few couple things. You know, of course, this thing is, you know, completely estimated, is going to depend on a lot of different circumstances. I also generally assume that 1099 contractors are paid more per hour if you break it down, largely due to the fact that they're not getting PTO and other employment protections. So um, it's you know, if you have a total employee wage versus a total contractor wage, and it's like sitting on a job posting or a website, it's not uncommon to, of course, see the contractor one be higher. Okay, good. We left at least 15 minutes at the end, which was purposeful. Doesn't really matter if my screen is sharing or not, but I'm happy to dig into some of these questions with you, Andrew.
I have a couple here. Yeah, I have a couple here that I kind of summarized that I didn't hear you speak to. So I'm going to get to those first. Do any of these rules change, David, if a business entity is classified or taxed as an S corp, such as an S corp contracts with a business, the S corp contracts with a W-2 employee? What are the implications of that? Uh-oh. Hang on a second.
There we go. Sorry, I muted myself.
Come back.
That was the Department of Labor trying to silence me. No, it doesn't. It doesn't change anything. Having the S corp versus, you know, whatever tax classification you have would not help. I guess maybe what that individual is trying to ask, I think, is Well, I don't know. I mean, are you saying that those people would all be employees?
I think so.
Yes.
If that was you asking the question about S corp, let me see here.
Doesn't change
Um,
my legal analysis. I don't
sure, I
care if
think that
you're
was
a,
from Taylor. Yeah.
no.
Okay. Um, Maybe the $64,000 question is what motivated this rule change? Like, why is the government doing this? What are the cases or things that went through the Supreme or the state courts or the appellate courts that are pushing this, pushing for this change or like informing this change?
Yeah. I mean, so, I don't get too much into the political, arena. I really just interpret and, pros and cons. But if you look back at the Obama administration, they tried to pass a somewhat similar rule. Again, not political, but the Democratic Party is more pro employee protections. I think you can take from this presentation that the big winner of this rule change would be the federal government, right? Having more businesses convert over to employees, which actually results in more net tax revenue, and in their mind, protections for workers. Whether you agree with that or not is really, I think, why this was done or why the Democratic Party want to do it. So anyway, the Obama administration tried to pass a very similar rule. It was actually overruled in the courts. This one maybe as well. We'll see. You would think that after so many years that you would kind of tweak it so it doesn't get overturned. The Trump administration, when they were in, they basically put in a towards the tail end of that administration, they basically put in a very pro business kind of stagnant rule and kind of cleared things up for everyone, which I think makes sense. And now it's kind of the end of the Biden administration. They finally got their stuff together and have passed this rule. Now, I didn't talk about this, and I won't ramble about it too long, but I think just the practical reality of what's going on here. It's an election year. This was, in my mind, sprung on the public and businesses quite quickly. I don't think the independent contractor police are going to show up on March 12th and kick down your door and
Mhm.
arrest you.
Sure.
Um, it's first the gig workers are going so Uber, DoorDash, you'll probably see your price if assuming the
Of
rule
course.
stands, those prices are going to go up. You'll probably see more employees there. You'll see big organizational changes. And then I think it works its way down into larger business players that have basically been abusing the rules since day one, unapologetically, and they just kind of got a pass due to the kind of the Trump administration's very low threshold. And then eventually it works its way down into your mental health uh, clinic that's using independent contractors, usually from large to small. But I would say the risk here, not to you know out anyone or give anyone any ideas, but you're this rule would give your independent contractors who were disgruntled quite a bit of leverage to complain to the U.S. Department of Labor, and then all of a sudden you're going through the motions with them, right? And so
Mhm.
not extortion, but it would be contractors that were aware of this rule and kind of knew how to work it, and they were frustrated with you for some much different matter, but they took a peek at their contract and they said, ah, you know what, I think they're breaking the 3 out of the 6 factors, so I'm going to complain. Anyway, it's a long-winded answer to why. So we'll
Well,
move on to the next.
there's a lot of inquiring minds that want to know, as you can tell, and it's a big change. This one has been asked a few times here, David. What is the Department of Labor's response, or has been their response so far, to contractors who don't want to be employees? Have there been any examples or instances that you know of where a contractor calls the Department of Labor and says, "I hate this. I don't like this. I don't want it"? I mean, what do they say in response to this, or what have they said?
Yeah, well, even before this rule came out, I can tell you it's they don't care. It's irrelevant. So the worker's opinion on the relationship is irrelevant. So the title you use, the fact that the business and the worker do not want it is irrelevant in the eyes of the Department of Labor, largely under the Fair Labor Standards Act passed back in the 30s that believes that workers don't truly appreciate and can negotiate and take care of themselves, right? And therefore the government needs to step in. So it's completely irrelevant. Even if your contractor did not want to be switched to an employee, they could put that in an affidavit. You could,
Mhm.
it's completely irrelevant in the multi-factor test, sadly.
Here's another one. Are there any rulings or legal challenges that you know of that will go through prior to the implementation date next month?
There are legal challenges. I can't speculate on when they will go through. Um, there's multiple challenges under very different legal theories in different jurisdictions. So people are pissed, and fortunately, they're all footing the legal bill to potentially overturn it for the rest of us. I can't speculate on whether it'll be done before March 11th, but maybe this will help that person's question or kind of brings up a different question. I do have a small subset of clients who do not plan on switching over to employees and will are going to assume the risk. So they are banking on either an overturn of the rule or they're strategically going to either be in partial non-compliance or a very gray area of law, and they're just going to ride it out. And I don't judge them at all for that. I just want to make that aware.
As
Although
therapists, we
they're
call that acting as if, David. Acting as if. The
acting
therapeutic.
as if, all right.
Acting as if nothing is changing.
Okay. Is that a good thing or a bad thing? Guess it depends on the circumstance.
I'll leave it up to the legal opinion on that one. Yeah.
Okay.
Another question here is how long do we have to be in compliance? You kind of spoke to that a little bit with like what are the choices? Some of your clients are choosing to act as if, others are choosing to change. And then is it a sanctions issue, a fine issue if you're out of compliance as a business owner who's misclassifying or determined to be misclassifying? What's the risk?
Yeah. Well, March 11th is the deadline. So, fines or, if you were violating overtime rules, those would toll as of that date. From experience, from being in labor investigations, if it's your very first time, there's obviously no guarantees that this is just from experience. I have had clients where it's when it's their first time, the Department of Labor is much more lenient on fines. Effectively, they say, listen, pay the back pay. We're going to ignore fines. Just get the worker as if they had overtime. So we've calculated it out for you in this nice spreadsheet. Presumably, this is the economic advantage that you've gotten by misclassification. And we're just going to mark this down as, first offense. Okay, goodbye. Whether that happens to you, who knows? Can't predict. The consequences would be fines. Technically, there is a criminal subcomponent, but without going into that rule, that would effectively be you emailing your other owner saying, we are going to purposely not comply because this is, BS, and we're going to screw over our every worker, and we're going to do this so we can make a bunch of money. It's like a very high standard of like purposeful intent, as opposed to what we're talking about right now, which would be good faith steps and movements in the right direction. That's a defensible, potentially civil fine, right? So like fine, not a big deal. So those are the two.
One other question here on, you spoke about clinical trainees. In Minnesota, we call pre-licensed clinicians clinical trainees. They're called, associate therapists in other states. Seeking clarification on pre-licensed therapists as contractors. Because they require by their regulatory board clinical supervision for licensure and ethics purposes, it's required for them to get that and to do their job, right? To be in compliance with their license that allows them to work. So how does this play into the labor change, the rule change here? because sometimes clinical trainees pay for that out of pocket. I'm from an era where we all paid out of pocket for that service from supervisors. Now it's largely a part of contractors or employees' benefits or fringe benefits or part of their contract.
I'll give an answer. I don't know if it's answering the question that's asked, but it kind of plays into my analysis that since supervision is required, that's such an intimate detail that we can't parse that into an independent contractor relationship. What you could do in light of the fact that they are benefiting from this big time is effectively just pay them minimum wage and or figure out a way that well, yeah, minimum wage, I'll say, is what I've seen most clients do there. There was another component, I feel like you said it at the second part of your question, wasn't there?
Well, so I was lamenting how it used to be, that clinical trainees had to pay out of pocket for their own supervision, whether they were contractors or sometimes even employees in some situations. The issue is, given the regulatory board's requirements for clinical trainees to be in compliance, who covers the cost of that supervision, and what are the implications for this rule change as a contractor or a W-2 employee? Because they're receiving a service that's right. It seems like that's what you're saying, that the employer has to provide it in order for the person to work there. And so it ties the two together. It sounds like the employer and contractor, or the employer and clinical trainee or supervisor who's offering that service. Does that make sense?
Yeah. But let me just play the devil's advocate very quickly. A clinical trainee, or whatever the official term, usually we're billing for them, right? They're going and seeing patients, we're billing for it, and we're making a little bit of money, right? So the government is not going to be as empathetic, right? Knowing that you're, making money, and yes, they're benefiting from supervision, but I'll just play the quick devil's advocate there. Now, I would hope that it would be enough money that it covers the cost of employing them, right? And maybe you're playing the game for a long-term relationship where they're going to be a first-year associate right out of school. That's that. I'll just quickly say that.
One other question about revenue size. Does this apply only to clinics that have $500,000 in revenue and up, or is it any revenue size for the labor change rule?
Any revenue size if you accept public funding. These are not ands, these are ors.
Okay.
So
as a part of the test.
or, yeah.
Okay. I am looking in the chat here to see if there's anything that we missed, and maybe David, you want to take a look as well.
Yep. Okay.
Someone asking about factor 5. How should we approach this if we are a mental health company contracting with mental health providers? Factor 5.
Factor 5, you're kind of screwed. It's this one that you're going to fail. Okay. It's this one that you're going to fail. So it's funny, the example that the Department of Labor used in their, I forget how many page guidance is, they used apple pickers on a farm. And they said, well, an apple farm, that is. They said, this is an example of work that is just so integral to the business. There's just, there's no way that it could be done without them, right? So it's a factor that works against them. Whereas the one that they said is not integral is they said a CPA or maybe a lawyer, although I beg to differ on the lawyer.
Yeah, on the lawyer part, huh?
But they said a CPA, for an apple farm, they just come in, they do the taxes, and they're out of there. So it's not an integral part, although I'm sure the CPA will say, without filing your taxes, you're screwed. So that was the example and guidance they gave. I think it's pretty hard to argue that without the mental health professional, how could you deliver mental health services? So not a fun factor.
That makes sense. Any more questions? You can pop them into the chat. I know we've got a couple of minutes here, just 2 left. If you do want the recording, please send me an email. I'm going to put it in the chat. And I think, David, you said that you may also post this on your social media links as well, or at least your
Yeah,
YouTube,
we'll
perhaps.
get it on the YouTube channel. Feel free to follow us on the socials, but yeah, we should have it on the YouTube channel. And I'm just scrolling up here. I might see a couple more, and I'm happy to see
Please do.
a little bit longer here. Okay. Uh, oh yeah, there's a lot. Okay, let's go all the way up to the top. I'm going to be thorough here. Blah, 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 blah. How do I make this bigger? I'm just going to get a close up of my forehead while I read all these. How do you suggest you document or reject the work or choosing schedule piece from EMI? Well, pretty simple. I would have a communication, could be an email from the contractor to you stating, I don't know how you set your schedules each week. You probably use some sort of software, but documentation that they have rejected a patient visit that was scheduled on their calendar, right? That would be great in terms of documentation. We're not going for like fancy legal, these are emails for documentation or screenshots, things like that. So just some sort of ability to reject that's documented in writing. Stop all training, said Aaron. Does this mean we can't even train them on how to use our EHR? Very good question. So EHR is one where I just don't think you can remove that from the company's ability to operate for most of these, independent contractor relationships. I just don't know how your billing would work if you were using payer, Medicaid type billing. So EHR is one of the limited ones where we are going to provide the materials, we're going to provide the software, and then we're going to try to have a bunch of other materials, things that the contractor is doing elsewhere. So very good question. I don't think you'd be able to operate if they stop using your EHR. I've kind of laid this out with some of the clients where it's like, okay, if they were truly an independent business and they had their own EHR, could we still bill UCare? And it's just a billing nightmare. So, and Tia added, and our specific HIPAA rules, we prefer that they actually do their own HIPAA training. Hi, Tia, good to see you again. Will the entity be a meaningful defense from Michael if that LLC only does business with your clinic? No. So we would prefer to see that entity, that LLC in your example, to do business with multiple mental health clinics. So I gave the example of two friendly mental health clinics where they cross-pollinated their contractors. That would be a fantastic way for them as their little LLC to be with at least two different clinics. Not a fun analysis, right? I mean, I'm kind of the buzzkill guy, or really the government is, and I'm just the messenger. But that's what I would do for that one, Michael. James said, "What about having pre-licensed people as independent contractors?" I think kind of, have gone over that one quite a bit with the employee rules. Alexis made the comment, "What if the contractor pays to be on the website? Can they be on the company website?" So I'll kind of do it as a spectrum, right? Terrible would be they are on the website, there's no disclaimer, they don't pay for it. Somewhere in the middle is they're on the website, but they pay for it because it's a marketing expense. This kind of looks like a business to business, and they're basically the way we want to think of it as, and the way you need to start thinking about this as, is as a business, they're leasing or they're renting advertising space on your website, almost like, Google Ads style, to like put their face on your website. And then the best would be that they're not on your website at all. They have their own website and they link over, or they don't. Sorry, remove that last part about linking over.
To that point, David, I've thought about this for group practice owners and would love your take. Is it almost like a group practice owner offering a service or like an infrastructure to a willing business that was buying a service or purchasing a service from them, access to insurance contract? Because there are other organizations out there that do this, that for independent
Yes.
therapists. Yeah.
Yes. So if we want to get really high level, right? I think a very safe potential pivoting business move, if any of you wanted to do it, would be to actually be what's called a third party management services provider or management services agreement,
Right.
where you don't think of yourself as an actual mental health clinic. You're just the person that happens to do the billing and you set up their website and you do all the things that the business doesn't really want to do. And then you have what's called a management services agreement, or basically an independent contractor agreement on steroids. And you do all the services, but then they're the ones that, it's their company on the letterhead and all that stuff. And
Mhm.
at the end of the day, you're probably doing the fee split the same. You're probably making the most money, but it's kind of a paradigm shift as to how we think of and set up from a legal perspective this relationship.
That makes sense. There are a lot
Uh,
of companies doing that for solo practitioners or solo clinicians to get access to service that they may not have because they're working alone or things they don't want to do.
all right. For proof of marketing examples, is 5 required? Tia said, Tia, that's arbitrary. That's just one that I picked. 5 felt like a nice strong number because usually my clients give me about 2. So I'm trying to get you ahead of the pack there. There is no official number that was released by the Department of Labor. Um, Serenity. So ultimately, this is supporting the theory that pre-licensed folks should not ever be 1099 correct. Yes, under a conservative reading of the rules. There's Andrew acknowledging some stuff we use. Okay. James said we use internal branded emails for security and HIPAA. Should that be changed? I think what you're really asking is, should the business have their own emails? This is another tough one, similar to the EHR,
Mhm.
and also would be very supportive of the example I just gave about the management services situation. But I don't think you can remove the EHR from the emails without not having the brand under the actual company, the biller. But if you can, if there's any opportunity for um, the contractor to use their own email to communicate with patients, it's HIPAA compliant. We have a business associate agreement. It's all okay at the end of the day. That would be lovely in terms of the factors. Um, so hopefully that has answered that question. All right. Oh, Tia, was this expanding? If we have all the 1099 rules followed, can we still allow them to use our company email? If we can avoid it, please do. And an email and a domain would be 2 really great entrepreneurial things for a true independent business to do, right? Whereas a company branded email looks and feels like an employee. But again, we're just trying to stack the deck so that we have a bunch of factors to offset the ones that we fail in our sub factor categories. That would be one that it seems like it's an integral part of the business and we just simply can't do it without. We brainstormed on 100 different ways to do it and they just don't work. So that may be one that you consciously fail.
Oh, sorry, David. There was
Yeah.
a question in here about client records. Given our requirements from our licensing boards and HIPAA to contain, protect, keep confidential client records, does that fall under the same like essential business operation piece like the EHR, in that the entity becomes the protector of the HIPAA information or protected health information?
Well, so it's interesting. Who originates the PHI is always my question. And
Mhm.
usually, right, that's the contractor, right? And they just happen to be using you as a biller. Again, I keep, because I've kind of been pitching this to a lot of clients lately. This would be a great argument for doing the management services setup that I just mentioned because it largely answers a lot of these questions for you. So without kind of avoiding the question, if you were an entity and you were using this, third party biller, everything else, you've removed that analysis because it's clearly going to be you that houses the records. You might have like the storage, right, at the MSA, but really you're the originator of the records, the true owner. Now you can transfer, um, you can have the ownership, change. I think traditionally what I see with, clinics like this is the entity is the owner, the contractor is just the, working on the files. So the files are actually owned by the billing entity, the type 2 billing entity.
Mhm.
Okay. I feel like
Other questions that you want to address here?
yeah, sure.
Over
I'm
time.
scrolling down and I
Yeah.
keep scrolling down and it just keeps getting longer. So I'll keep at it here. Semena, I hope I'm pronouncing that right. I feel like having individuals who are marketing themselves are then marketing their own business, not marketing for the business they are contracting for. This feels confusing. Yeah, I agree. But that's kind of the whole point. A true business should be marketing for themselves, right? You kind of get the minor distinction there. And the reason we're doing that, even though they may not, really want the business coming in, is that if they were a truly independent business, right, they'd be out there kind of hustling and trying to get their own patients. So
Right.
yeah, it is very confusing. And I anticipate a lot of contractors don't want to do that. They don't want to throw their mug on a website and, go do a photo shoot and have a, get a couch here and have somebody, everything you got to do and all that branding. What's the
Right.
reason? We already answered that one. Um, Jessica, hey, how's it going? Good to see you. How would the 1 year max term go with insurance contracts? Would 1099s need to be renewing insurance contracts under our type 2 NPI every year? Um, yeah, yeah. I mean, if it had an end date, if that's what you're asking, um, largely so that we can pass the factor of not having a permanence, right? An agreement that just goes on forever. We have the fixed term and then we're negotiating at the end. Aaron asked a good question here. How do you force contractors to seek additional work? I use that term very liberally because as a true independent contractor, we want them to independently come to these conclusions, but also we're kind of forcing them because we're up against this deadline, right? And we don't want to be the ones that take the blow. So, force I'm trying to think of a better synonym for the word force, but strongly encourage or,
Invite.
offer
Even.
after, yeah, invite. After March 11th, these are the only options for continuing to work at our company as a contractor. And, it's kind of an A/B test, right? You're either coming down the employee route, you're going to do what our attorney has told us to do, one of which is seeking additional work so we get away from the economic dependence test, or we're going to, show you the door. Um, Michael, you mentioned audits here. What would I be looking at with a complaint if a relationship sours? For example, a therapist only worked for me, making 80K a year and terminated them and it wasn't amicable. They file a complaint. What sort of sanction as a percentage of 80K would I face? Well, all of the math is going to come down to first, did we fail the multi-factor test, right? That's kind of the first line of reasoning. If so, then we're looking at overtime pay. Was overtime pay due? Did they work over 40 hours in a week? If yes, then time and a half would be the first type of fine that you would face. That would be paid back to the worker. Um, Second would be minimum wage, right? So if there were periods that there wasn't minimum wage, but it's going to be a mathematical mess if you're doing a percentage because you probably have areas where you might move below minimum wage for a week and then areas where you're way above. And then, of course, there's the option of fines, basically liquidated damages, that sort of thing. So that could be on top. The S corp question doesn't change. S corp's W2. Yeah, I mean, if that question there, Taylor is saying that you're going to switch people over to W2s, that's awesome. I mean, then there is no multi-factor test. Maybe that's not it because that sounds too easy of an answer. But no,
It would be
if
so
we're
simple.
the, if y'all don't enjoy this multi-factor test, switch them over to employees, right? And then you'll never hear from me again. Well, you will for labor, employment law issues, but those are different. Um,
David, you're able
Yeah.
to assist with the calculations and the percentages and getting folks converted over. Yes, or is that a CPA concern or issue? If people do want to switch their staff from 1099 to W-2, that's a lawyer, that's a CPA, that's both.
Yep, we help. Minnesota is kind of the asterisk there, right? Because
Sure.
it would be state law specific at that point. We have packages, we have a flat fee package where we will do the analysis for you. And then if we determine that some of your people are employees, we kind of tell you how to do that, right? And kind of a limited scope. And then we have a much more hands-on, like, I want all 20 people to switch over to employees. I want the full, shebang. And so we have
Sure.
prices for both those.
Got it.
Okay. I'll keep going here. Why not? Tia, gosh, you're just very active. Good job. So we got a 1099 that's seeing less than 5 clients a week and works full time elsewhere as a W-2. I think you're asking, is that good? I think it's good, yes, for the economic dependence factor, or sorry, it's not a factor, it's kind of like a overarching that's a factor. Let's call it a factor. It's not one of the 6 core ones, but it works well there. But you still have the other 6 factors, right? So it's like, yes, but it doesn't like automatically become the trump card like it may have used to be. Moving down here, I totally agree with you, Michelle, on contractors not wanting to be employees. Government does not take that, US Department of Labor does not take that into consideration, unfortunately. Largely frustrations here I'm noticing, which I can empathize with.
You can also do the management services agreement package if folks want to try and go that route as well, I'm assuming. Like have a conversation with you about setting that up if they don't already have one, and then moving their business practice towards that kind of a setup or structure.
Yes. Just going through here, I think I'm actually kind of close to the end. Do we anticipate any rulings? I think I already got that guy. How long? If we have to fix this, it would be March 11th for the due dates. Yes, we can get you a copy of the PowerPoint. Large fines. I think I kind of commented on what that would look like. Yeah, this I think was the pre-licensed rant that I did.
Clinical training check.
Factor 5, we're screwed. Yep. Tia, there you are again.
We appreciate your candor. I heard that too.
Yeah. It's not just 500K. Those are all ors up there. So if you had Medicaid, for example, and you only did 100K. Billing under a supervisor make a difference for limited license contractors. Like billing under a supervisor. No. Same legal analysis there, Becky. Yep. Michael, I think, was trying to answer Tia. Oh, but if private pay, curious about this. I love the little sidebars in the chat here. So, no, the private pay distinction. Oh, you're only private pay. Well, then yes, you're not taking public funding, so that or is a no for you. Now, are all the others good? So interstate commerce under 500K. You can have, I think this person's just answering somebody else. PowerPoint.
The last question here, David, maybe you kind of lump this in with the clinical trainee, but interns, do they need to be paid? Graduate students that are completing their internship with the practice, can they not be paid? Do they need to be paid? Is it minimum wage? What's your take on that?
Yeah, so even like let's just throw this independent contractor analysis out of our heads. Interns already have a whole layer of other rules. Basically, we're trying to prevent slavery, right? People working for nothing. So, there's a whole separate rules on what the government will look at to make sure that the person is receiving some substantial benefit from the relationship, which I think you have a fantastic argument. They're getting great work experience. This is worth a lot of money as an industry standard. People even sometimes pay for this. So I think you've passed that test. Interns, though, are always a trap because you're in this goofy area of, are they getting school credit, or are we just kind of paying them,
Sure.
the bare minimum that we can until they are actually a little bit more productive? I think as a general rule, I think I hinted at this earlier. If you're going to make money off of these individuals, interns, whatever, it's kind of tough for you to then turn around and sit there with a straight face and say, yeah, but I don't feel like I should pay them. I think like they're getting a really good benefit. And then you're,
Mhm.
billing, 30, 40, 50,000 off of them. And really none of that is flowing down. And maybe they're getting educational credit, which they're also coincidentally paying for through their
Sure.
tuition.
Mhm.
So
Mhm.
it's a little bit more complicated answer than um, it it would have to be. I would say as a general rule, I mean, again, employees are always going to be the safe classification, but absent that, I like schools that have a more formal faculty advisor. They already have the written agreements, something that we can work off of to establish a nice foundation, because their interests would be aligned with ours if we were under an audit.
Right.
Okay. Documentation of the schedule. I think I got that. Just emails, anything in
Mhm.
writing. Yeah. So Jessica brought up the EHR. We are changing to charges per user. So having them cover that cost per month work to help separate that. Yes, it does. It's a great example of a, little administrative fee that then they're paying for. You're still forcing them to use your EHR. So it's not like, yay, it's kind of like okay, a little bit better than nothing in that category. Ooh, Chelsea asked, do we need to have separate client onboarding paperwork?
Yeah. So you spoke
Again,
to
kind of goes up into
HI.
the bigger paradigm, shift if we can do it, which would be, who is actually providing the services, right? Is it the company through the contractor, or is it the contractor and they just happen to be using the company to do all that, behind the scenes billing crap that, nobody really wants to do. So um, it would be lovely if each contractor had their own paperwork. I think you're going to, I think maybe you're trying to parse it out and say it's their onboarding paperwork. Maybe they're only doing the health history, I think is maybe what you're suggesting. If they were doing their own legal paperwork, you know, and then they're contracting with the company to then bill, that looks and feels like the model that I described earlier, which would be the management services model, right? So if you could do that, that'd be a fantastic factor. So I'm gonna give it a thumbs up. But that's a good note here. If we are fee splitting, Taylor asks, if we're fee splitting, don't we already pay for that infrastructure? I think you mean the billing infrastructure. What do you think they meant there, Andrew?
I think so. Yeah, that seems to be the back to the administrative services agreement. Like, who is the billing entity, and don't the contractors already pay for that with their fee that they don't get, right? If they're on a fee split and they get 60% and 40% goes to
Yes.
the billing entity.
Yeah. Yeah. So in the contracts, I usually call it an administrative fee, and then I list all the things that covers, right? That's what they're paying for. So yes, that's what the fee split is for. That's kind of the fair market value, what we are doing. In a perfect world, we try to apportion those out so it's, per call, 30
Sure.
cents, and per, billing submitted, 8% of the, collected item. So
Itemized.
yeah, that would be a great way to kind of break it down and make you look and feel more like a billing or service provider, as opposed to a clinic that's benefiting from the labor of this individual. And we just happen to dress it up with a fee split. Okay. All right. Thanks, Joe. Have a good weekend. does this ruling mean that interns need to be paid and no more unpaid labor? I think I kind of parsed that one out. Uh, let's not focus on money, but let's focus on um, the benefit that each party receives. So if you're making a bunch of money off of them, but then it's unpaid labor, probably bad. Uh, and let's fixate more on the substantial benefit that they're getting, all this training that you're documenting, all this like professional development that you're pouring into them and documenting all this, supervision and kind of mentorship that you're doing. Let's focus more on that as opposed to a yes or no question on the unpaid labor. So no, that's not what I'm saying. um,
And there really isn't a way, short of charging the intern for that time, to parse out the value, right? Or to assign the value to it. If you as a clinic are making money from the intern's billable time and then offering them the training, the supervision, the development, what's the dollar amount on that? Is it a per hour rate? You see, I think that's what you're saying is like, how do they justify, or how can you justify the value of what they're getting in writing, maybe?
yeah, I think there's value going both ways usually on these relationships. You're
Yeah.
making money off of billing for them. They're making, experience off of working with you, maybe for free. And you're allowed to have a hybrid model where, we acknowledge that they're getting a bunch of experience and we just happen to be paying them minimum wage because, we just want to stay away from all Department of Labor and, minimum wage considerations. Um, so it's a spectrum. Cool. We're at the bottom here. Sorry, I missed what he said. If you're solely private pay, this does not apply. What if you provide documentation for not Medicaid, Medicare? So let's go back. These are ors. So if you're private pay, you're saying that I'm cross out this one. There are other limited situations. So, unfortunately, I'm, limited on time, but, if you're going to rely on only this and not hire an attorney, just do a quick, make sure those other limited situations don't apply. If you're not doing interstate commerce, so if you're doing telehealth to multiple states, that should be a consideration that this rule would likely apply. And then also if you're under 500,000, so we'll just take, you're only private pay, you're only in Minnesota, you're making about 250, this rule would not apply. And you survive these other limited situations with my little asterisks. I don't give you an absolute. Okay. Onboarding question relates to the tip about the separate HIPAA information. Yeah, I won't go into that one, unfortunately, because I'm out of water. It's okay to have both W-2 and 1099s, right? Said Nicole. Like 4 interns are W-2 and the rest are 1099 contractors. It doesn't have to be one or the other. No, it doesn't. You can have a hybrid workforce. That is totally fine. But here's the trap. Really good question. For those of you that stuck around and get the bonus of hearing this, or if you're watching it later. The temptation is to have 2 templates, your employee and your contractor templates. And the only thing you changed in the whole thing was just a little bit on the payment. But everything else kind of looks and feels the same. You train both of them, you treat them the same, you use the same software, they come to the same trainings. That would be really bad because it demonstrates that you don't understand really the key differences. You haven't really considered the multi-factor test. If you're going to use a hybrid workforce, we want to treat people differently. And actually, we want to really document how differently we've treated them. And, it's kind of like they're like completely different teams of people or categories of people. And, under an audit, I would actually utilize, hey, we actually have employees that do way different stuff over here. Look at all the things that they do. We know what we're doing. We didn't do those for the contractor. So it's a potential trap, or it could be a benefit if you do it right. Can absolutely have a hybrid workforce. Thanks, Jessica. And I think I made it. So, oof, I need more water. Thanks,
I
everybody.
was gonna say, caffeine time or something.
Yeah, so we'll get this out to everybody. Really happy to present. I got my contact information here. Follow us on the socials. I'll I'll try and get this up on YouTube and obviously wherever, you throw it up, Andrew, I'm sure you can link it.
Yeah.
I'd
I've
imagine
already
some
had some
email goes
emails.
out. Yeah,
Yeah, I've
yeah.
already had some emails asking for the recording, so that's great. Andy at sparrowsearchservices.com. David, you've got your info on the socials and on the website. And the recording will be available sometime in the next week or so to send out, and we'll have it posted. If you need any help legal, David's your guy. Glad to help you with your recruiting efforts for mental health professionals. Thanks so much for your attendance, for putting up with a couple technology hookups, and we're cruising into the weekend. Everybody
Thanks
take
all.
care, be well, and we'll talk soon.
Have a great
Bye-bye.
weekend.